All right, let's quickly get into our interview now. Election Monitoring Network Chairperson Nkosikhulule Nyembezi says Parliament should guard against citizens concluding that the institution is ill-equipped to manage the wayward behaviour of politicians driven by self-interest. He says this could force the public to find the Constitutional Court is the only place suited to police parliamentarians. And he was responding to the Department of Home Affairs' rejection of all objections raised by the public regarding the Electoral Amendment Bill during the countrywide public hearings process. Policy analyst and chairperson of the Election Monitoring Network, Nkosikhulule Nyembezi, joins us now to talk about this. Great to have you. Thanks so much for being with us on Morning Live.
Thank you. It's always a pleasure.
So you're quite scathing in your unambiguous views there. I mean, why is the DHA opposing the concerns and objections proposed in the bill? Isn't that what the public hearings are actually about?
That's what the public hearings are about. And that is what the Constitutional Court said, which triggered these public hearings, to say the right to stand for public office and to hold office if you are elected is put there without any qualifications. It must be facilitated. And all these submissions that sought to give meat to that skeleton as to how that right should be facilitated, they seem to have been thrown out of the window. So the bill as it stands now for to be debated, tabled and debated in Parliament, it doesn't speak to the facilitation of enjoyment of that right.
Your contestation is that the overarching theme of this process and response by the department is that political parties are positioned as rightfully entitled to contest elections, which appears as if the mindset is begrudgingly forced to move away from the entrenched party system. But the process embarked on here emanates from the Constitution. I mean, do you sense that there is a resistance at the moment?
Yes, there is resistance at the moment, because what we know is that when we interpret this right, we have to take into account two or three things that are important. One, the historical context, and two, the plain language of the Constitution. The historical context is that in 1994, we went to vote for the first time in democratic elections coming out of a negotiated CODESA process. We put political parties as the rightful vehicles that must appear on the ballot paper, because we didn't want to infuse the constituency system, because that could have led to a tribalism, racism referendum, because people might have voted for people who speak their own language or who is of their tribe. Mm-hmm. So political parties helped us with that transition as being the only contestants. But when we had the new constitution in 1996, the issue was we need to get an electoral system that graduates this, and we still haven't. So that is why now you see that there is resistance, especially because political parties are debating this legislation, not just to facilitate their rights, but also because they are also interested. Those 400 seats in national parliament are occupied purely by political parties. When you open space for independent candidates, 200 of those seats are likely to be taken up by independent candidates. So political parties are keeping their self-interest in not framing the Electoral Act and the system in a way that facilitates for independent candidates.
Quite a few hurdles that have been picked up in the process of allowing individual candidates to contest elections, including issues of thresholds in terms of numbers that might needed to be there per candidate, the filling of vacancies, and also by-election midterms through. So funding concerns is also a very, very big one. How should these be dealt with?
They should be dealt with plainly in terms of the historical context. Black people and a lot of other races were excluded from participating in elections. Now we must facilitate that to include them unconditionally, understanding that political parties are only a vehicle to get there, but there's no requirement to be a political party to vote in South Africa. The issue of thresholds that we're talking about and the deposits, they are just should not be burdensome, because what we see now, it looks like political parties will be required to provide to get less threshold, and independent candidates must get more votes and upper threshold that is disadvantaging independent candidates. On the issue of the deposits, it looks like the amounts that will be asked are unreasonable. What we need to understand is that democracy is expensive. We just need to facilitate for the right, and we must allow for all those who can contest to be able to contest, because elections serve two purposes largely. They have a deliberative value, expressive value, because when people campaign and put forward the election manifestos, they bring up a lot of issues that we as citizens are concerned about. And a lot of those issues are usually overlooked by political parties. And number two, when people vote, to say that we have a choice of somebody that you can vote for, irrespective of whether they win or not, is something that gives legitimacy to our democracy. So we cannot narrow it down at the process of how you how to contest it. We need to make it unfettered as the constitutional right with no limitation.
Who is actually supposed to have the final say to make changes to the bill? I mean, what about the public? To what extent do public hearings actually play in this role?
Public hearings play an important role because we give the details as to how we should operationalize this right. In fact, the first detail is how we should conceptualize this right, to say that everybody must be allowed. There must be no unreasonably high qualification method. We must stick to what the Constitution and the law says. To vote and to be voted, you must be 18 years old, you must have a South African ID, you must register in the voters' roll. The citizens must have the final say, because Parliament is elected to represent the people, not political parties. The role of the Constitutional Court and the Electoral Court and other courts is important, because we see now that political parties have got a selfish interest that they are protecting. So to the extent that this process was forced by the judgment of the Constitutional Court, the expectation is that if Parliament can, with the majority of the ANC, bulldoze the process and pass the legislation as is, maybe the president will not sign it. Maybe he will refer it to the Constitutional Court and say, please confirm for me that all is in order. Otherwise, if he does that, it means those who feel that they have been overlooked in this public hearing process will have an opportunity to make submissions to the Constitutional Court, and I doubt it will pass the legislation. But again, even if the president doesn't do that, he continues and signs the legislation, there will still be an opportunity to go to the Constitutional Court and challenge the legislation, because it has to meet those conditions as per the Constitutional Court judgment.
So the bill, it was introduced in Parliament only in January this year. I mean, this, of course, was in response to the Constitutional Court judgment in June 2020, which found that the Electoral Act was flawed. What took so long?
I don't know. It could be that COVID, it could be that they were investigating, it could be that political parties are resisting to introduce these changes, because it's not supposed to have taken this long, but nonetheless, it was tabled and the hearings took place and people expressed their views. And as we know, the right is there in the Constitution. And there have been other judgments, for example, the Ham judgment, where it was said that independent candidates are equally entitled to all the considerations that are currently being given to political parties. You must get the voters' roll before the election so that you can know who to target your campaign to and all that. So there must be nothing in this bill that advantages unfairly political parties. From the period, because we know the elections are divided into three: the campaign period before the elections, the voting day in terms of what happens inside the voting station, the counting of votes and the conversion of those votes into seats. All of that must comply with the law and not unfairly advantage political parties.
We've got general elections coming up in 2024. This Electoral Act, will it be in effect in time?
It has to. It has to. Come rain, come sunshine, it has to, because there isn't much that needs to be put in place that we don't know about. We just need to give access to the right as it is without putting the leg on the drawing of a snake. So we also have comparative electoral systems, starting with the municipal elections. We know that at municipal level, you don't have to be a member of a political party to contest. We must graduate that system. But also we can also look to remove some of these issues that are controversial. For example, the paying of deposits, asking for so much money. Now we have for Tezondo Commission, evidence of corruption. So if you can remove that issue about paying for a deposit that is so big before you can contest, we remove this possibility that whoever can sponsor you with that amount to go and pay the deposit so that you can contest, you are already beholden to them. We must make the system easy for people to participate. So there is nothing complicated to stop the passing of the bill in a way that is compliant, such that in 2024, we have independent candidates contesting at provincial and national level.
And this is where I want to sort of take the interview, and I know we basically finished, so let this be my final one too, because, you know, we have an interesting feature in our democracy. I mean, South Africa is a multi-party system operating by the principles of proportional representation. But of course, as you mentioned now, the introduction of independent candidates in national and provincial elections, this does throw a spanner in the works. I mean, what will this now, I suppose, the system be categorized as now?
Well, electoral systems can be understood in a line of a continuum. One extreme is a one-party system. The other extreme is a multi-party system, pure constituency. And then what we see in between is something that fits the country. So we can still frame the electoral system in such a way that both political parties and independent candidates contest alongside in order to give voice to the people, because we must give legitimacy to the people. So there is, it will still be a proportional representation system. But when we talk about multi-party system, we must not have an illusion that it's a political party system. Parties can mean sectors of the society, women, children, youth, you name it. So political parties are only a vehicle, but they can be civic organizations, they can be burial societies. They put their name, we see them in the ballot paper. So that is what we need to graduate our system to be able to take into account this historical context so that we can adhere to these values. And we say Section 7 of the Constitution demands and puts duties on Parliament to respect, to protect, to fulfill, and to promote democracy. So they must deal with this process in a manner that is consistent with Section 7.
All right, and Nkosikhulule Nyembezi, thank you very, very much for talking to us. Policy Analyst and Chairperson of the Election Monitoring Network, talking about the challenges regarding the Electoral Amendment Bill. So the Constitutional Court had given Parliament 24 months to amend the Electoral Act to be concluded by June this year. Parliament has asked for a 6-month extension until December.